Good afternoon, and welcome to today's caregiver webinar, Legal Considerations for Family Caregivers. My name is Allegra Jaffe, and I am the supervisor of the Caregiver and the Supportive Service Unit with the Fairfax Area Agency on Aging. A few housekeeping items before we begin today's session. So today's presentation is being recorded. A link for the recording will be sent to all the registrants within a week from today. You have been sent the PowerPoints today. We will send those to you again, just in case you missed those. At the end of the presentation, we will do Q&A. So you can utilize the question and answer box on your Zoom panel and feel free to ask questions at that time. And if you can take a moment at the end of our presentation, we are doing a quick survey. It really does help us create relevant and important information for our family caregivers. And so I would love to introduce today's two speakers. We have Virginia Haizlip, served as the president of the Northern Virginia chapter of the Virginian Women Attorneys Association for 2019 through 2020, is a member of the Collaborative Professionals of Northern Virginia, the Virginia Academy of Elder Law Attorneys, National Academy of Elder Law Attorneys, and the Virginia Bar Association. Virginia was named as Rising Star by Super Lawyers for Virginia every year, 2010 through 2019, for the District of Columbia every year by Super Lawyers for Virginia, every year from 2013 through 2019. She has been named to the Virginia Super Lawyers list since 2022. Virginia was named as an influential woman in the law in 2019 and has been designated as top attorney by Arlington Magazine, Northern Virginia Magazine, and has been named to the Legal Elite by Virginia Business Magazine. Virginia practice focuses on guardianships and conservatorships, special needs planning, estate planning, and estate administration, divorce, child custody, and child support. Virginia has been in the practice of law since 2005. She graduated from the George Washington University School of Law. Virginia was drawn to the practice of guardianships and conservatorships, special needs planning, estate planning, and estate administration because she can interact with people and assist them in solving their legal problems. She notes, having experience and knowledge about many different options allows me to help clients evaluate what approach is best for them. Elizabeth Gray has been practicing law since 1996. She is a member of the Bar of Commonwealth of Virginia. Elizabeth focuses her practice in the areas of elder law, special needs planning, estate planning, guardianships, and the administration of estates. She has developed a reputation among her peers in the legal community as the go-to person in the areas of elder law and special needs planning. She is a past president and 2011 recipient of the Outstanding Member Award of the Virginia chapter of the National Academy of Elder Law Attorneys. She's a member of the National Academy of Elder Law Attorneys Invitation-Only Council of Advanced Practitioners, a member of the Invitation-Only Special Needs Alliance, and former co-chair of 3 different sections in the Fairfax County Bar Association: Elder Law, Wills, Trust Estates, and Practice Management. Elizabeth also sits on the board of directors for the ARC of Northern Virginia. Thank you so much, Elizabeth and Virginia, for sharing your experience today. Ladies, if you could come and join me on screen and take it away.
Thank you so much to Allegra for having us. We're looking forward to sharing this with all of you. Okay. So let me just back up a little bit. We are here to share with you about legal considerations for family caregivers. In this presentation, we'll talk about various aspects relating to whether you're caring for a young adult with disabilities or perhaps a senior, any family member or loved one that may need some additional assistance. So we'll talk about various aspects of the law. Liz and I are partners at the law firm McCandlish Lillard. We have included contact information, so if you have questions following this presentation, please feel free to reach out at this email address. Either of us is happy to speak with you and answer questions may be specific to your situation. So we wanted to start by just talking about the basics of estate planning. What is estate planning? Who needs an estate plan? And the answer is really everyone. Every competent adult who's over the age of 18 should at a minimum have a durable financial power of attorney that appoints one or more agents to handle financial and legal affairs. Every adult should have an advanced medical directive with a living will and a healthcare power of attorney. This is a document we'll talk more in depth later. But again, it appoints an agent to make medical decisions for someone if they can't make those decisions themselves. And it specifies what type of medical care they would want to receive in certain situations. And lastly, a last will and testament and or a revocable trust that deals with what happens to their assets at the time of their death. I think there's a misconception out there that if you don't have a lot of assets, you don't need to do estate planning. That's only for wealthy people. That's really not the case, and you can save your family a lot of heartache by doing some planning in advance. If you are a parent of minor children, you also need to name guardians for your minor children in your last will and testament, as well as an appointment of standby guardian, someone who could step in and care for your children if you're not able to do so in the event of emergency. So what happens if someone doesn't have the capacity to sign these types of documents? And when I talk about capacity, I'm talking about cognitive ability. There's different capacity determinations that apply to different types of documents. But in general, what we mean is someone has to be able to have a basic understanding of the documents they're signing, what they do, who they're appointing in those documents, and they need to be able to enter into those documents with a minimum level of understanding. So if someone doesn't have that, then you may need to look at being appointed representative payee for Social Security, establishing guardianship or conservatorship in the court if they don't have those documents and they're not able to sign them. Okay, so options to care for your loved one. So what can you put in place if your loved one needs some assistance? So when we're thinking about financial issues, there may be the option of using a power of attorney. If the person has an existing power of attorney or they're able to sign a power of attorney, they may be able to appoint you or others as agents to manage their finances. If not, then you may need to look at a conservatorship, which will give you authority by a court to manage the person's finances. You can also use certain types of accounts like uniform transfers to minors accounts that will set aside money for children until they reach certain ages. 529 accounts, most people have heard of. Those are accounts really intended for college or education savings. ABLE accounts are less well known, but those are special accounts that are created for adults with disabilities and can hold money for those individuals. And as we said, you can be potentially appointed as representative payee for Social Security benefits or other government benefits. If they need help with medical or personal decisions, they may be able to sign a healthcare power of attorney that includes a HIPAA release, allowing you to access medical information. They may also be able to sign a special type of advanced medical directive if mental health issues are a concern that allows you access to their medical information and to make medical decisions on their behalf. If they don't have the capacity to enter into those documents, then you may need to look at a guardianship. And if this is a person who is engaged in education, either at the high school or college level, they may be able to sign a release to allow you to get access to their education information directly from the educational institution.
So now we're going to talk a little bit more about wills and trusts. And we're going to start with wills. And most people understand that the assets in wills go through probate. It's a public event. Anybody has access to anybody's will. That's why we know what's going on with Aretha Franklin's estate, and that she wrote 2 wills and one was found in her couch. That's because we can all go and look at her will, and it doesn't give you much privacy. If you're a caregiver for an adult with disabilities, that piece in itself makes me nervous, because anybody can look up and see that you have a special needs child. The court is really supervising the distribution of the decedent's estate. So for some families, they really want the court supervision. For other families, it's not necessary. It is time consuming and expensive. Every time you go to court, you need to pay another fee. And the thing that a lot of people don't realize is that not all of your assets will go through your will or go through probate. The only assets that go through probate are those assets that are in your name alone without a joint owner. You don't own the asset jointly with somebody, or that have a designation of beneficiary. So like life insurance has a designated beneficiary. If you've designated a beneficiary and die, it will go directly to that beneficiary outside of probate. And now we're going to look at trusts. So the assets in the trust avoid probate. And that's because the trust is really like a container, like a cup for your assets. You have to put them into the cup. It gives you privacy because it's really a contract and nobody gets to see it unless you allow them to see it. There's a lot more flexibility in drafting a trust because we can put in all kinds of bells and whistles. And it's a lot quicker at the end of life than a probate process. So oftentimes we can have the distribution happen fairly quickly. And it also helps to avoid guardianships and conservatorships. I should back step and let you know, guardianship is the person that makes the healthcare and living decisions for somebody with incapacitated state. And then conservatorship is the money piece. It gives somebody the authority to make those financial decisions. And I tend to bundle them all up into guardianship instead of saying guardianship and conservatorship. So the trust is an avoidance option as well, because it works while you're alive and capacitated, and it also distributes your estate like a will does when you die.
Okay, so you really led us right into the next topic, which is guardians and conservators. So as Liz said, the guardian is the person who makes medical and personal decisions. So what medical treatment will someone receive? Where will they live? Things like that. A conservator is a person who has control over the individual's assets. And they can be the same person or they can be different people. So we'll talk about that a little. When we're thinking about guardianship and conservatorship, and I also tend to use guardianship as shorthand for both, most of the time, the guardians and conservators who are appointed will serve for the remainder of the incapacitated person's life. It's unlikely in most situations that the person will regain capacity and be able to manage their own affairs. That's not true in all circumstances. Sometimes there may be a need for guardianship or conservatorship on a short-term basis if someone has mental health issues and they're going to receive treatment and regain capacity, or perhaps they have some other medical issue, but they're being treated and will regain capacity. It's also possible that sometimes the guardian and conservator may not need full powers. So the person may have some limited capacity, they may need some help, but they may be able to make a lot of their own decisions. And in those instances, it could be what we call a limited guardianship or conservatorship. Or sometimes the person may need a guardian, but not a conservator. In the example of perhaps a young adult who has recently turned 18, and have intellectual disabilities of some sort, they may not have resources of their own. So a lot of times those people don't need a conservator because they don't have any assets to manage, but they may need a guardian to help them with medical or personal decisions. So when to file for guardianship? You can file at any time for the person 6 months before they turn 18 or any time thereafter, assuming they do not have capacity. So how does this process work? The petitioner is the person who's filing the case, usually, not always, who's seeking to be appointed guardian and or conservator. So initially, the petitioner will obtain a medical report. They will work with the individual's physician or other medical professional to get a report. We then take that report as attorneys and we prepare a petition for guardianship and or conservatorship. And that medical report will be attached and will be filed under seal with the court. Excuse me. Once that petition is filed, the court automatically appoints a guardian ad litem to represent the respondent's best interest. The respondent is the person that we're seeking guardianship and conservatorship of. And the guardian ad litem will investigate, they will file a report with the court. So the guardian ad litem is an attorney who's trained in these type of cases, and they will meet with everyone who's involved and give their recommendations to the court. The petitioner, usually through their attorney, prepares the required notices. So we have to tell the respondent when the case is going to be heard and what their rights are. And then at the time of the hearing, the court will issue an order granting a petition, granting or denying the petition. The vast majority of these cases that come before the court end up being what we call uncontested, meaning there's no legal disagreement about what's going to happen. And in those cases, the case moves through the court relatively quickly, generally about 2 to 3 months, although I have certainly seen them go more quickly when there's an emergency situation. And sometimes they take a little longer because of availability or the court's dockets. But generally 2 to 3 months is a reasonable time frame to expect. Once the order is entered, then the guardians and or conservators will do what's called qualification. So they meet with the probate clerk, they take various oaths, they may have to pay a bond, and then they are empowered to act as guardian and or conservator of the incapacitated adult. So that is a formal legal process. And once you're appointed, there's various reporting requirements afterwards. And it's important to make sure you understand all of your obligations once you undertake this on behalf of someone, because it's very important to fulfill those obligations.
The court just made a change that in some cases they want to relook at the guardianship.
Yes, the court is in certain cases setting review hearings for 6 months to a year after the initial determination. Right.
It costs even more money.
That's right.
So for advanced medical directives, let's talk about those. And the purpose is to appoint somebody to make your healthcare decisions at a time when you cannot make them, and to designate your preferences for end of life, whether you want treatment to be withheld or withdrawn. And then it can also specify your wishes as far as anatomical gifts and the disposition of your remains. And then we also try to include a HIPAA release, which authorizes somebody to get your protected health information. In order to sign an advanced medical directive, you must be over the age of 18. It must be in writing and witnessed by 2 unrelated people. We just have 2 people on there, but sometimes people don't think about it, and they'll have the person that they're naming as the agent as the witness, and that won't work. You have to have capacity to sign one of these, and you can revoke it at any time. Virginia has a healthcare registry. I think we're up to 22 states now have these registries, That's an electronic cloud platform to hold these documents. And it's great because you can upload it to the registry. They'll send you a wallet card. And if you're unconscious, they can find your advance directive and other related information like your medications and things like that on the registry. One thing that people get mixed up about advanced medical directives is that they are not do not resuscitate orders or DNRs. That is something that a doctor has to sign, and your agent can sign it on your behalf, but it's a separate form. The advanced medical directive just gives the agent the authority to do that. For the financial power of attorney, this is to appoint somebody to make your financial and legal decisions. Again, you have to have capacity to create one, and it must be notarized and witnessed by 2 individuals in order to be recordable. And why would you want it to be recordable? Well, if there's anything to do with real estate, you're going to want to record that to show everybody that you have the authority to sign any real estate documents that are recorded for that person. So there are a couple different types. There are springing powers of attorney, and those are powers of attorney that have an on switch. And in order to trigger it on, oftentimes you have to get 1 or 2 doctors to certify in writing that you don't have the capacity to act on your own behalf right now. We hate those.
That's true. They end up being far more trouble than they're worth because of the banks, usually the financial institutions, are reluctant to accept them.
That's right. And try getting a doctor or 2 doctors to sign something about your capacity. They're not going to feel comfortable doing it. They're going to want you to see a neurologist. That's going to take weeks and weeks. Meanwhile, your agent can't act.
Right.
So we like to use durable powers of attorney that are effective immediately when you sign it. And the only thing is that it's really important to us that you pick somebody that's good with money. Virginia always tells people if they can't balance their own checkbook, they will not be able to balance your checkbook. And that's so true. And you also have to make sure that this person is trustworthy. Are they going to act in your best interest? Even if they're good with money, are they going to do something that they shouldn't do? So it's just important to pick the right person.
Mm-hmm.
You can have a general power of attorney that lists specific things, or a specific power of attorney just for one thing or for a short time period. If you're going to go overseas for a couple of months, you might do a specific power of attorney for that time period. Or if you want somebody to sell your real estate and that's the only thing you want that agent to do, you could do a specific real estate power of attorney. The thing about the powers of attorney and the advanced medical directives is that when you die, they die too. We always get calls from people saying that their mom just died and they're the agent under the power of attorney. That means nothing once the person's died. So when we talk about people managing others' money, we want to make sure that that agent is keeping careful records of all of their transactions. So we always suggest that you get a notebook and you just keep track of things that you do. You know, on March 12th, I went to the bank and took out cash to pay the caregiver or the certified nursing assistant. And just keep track of what you're doing in also keeping track of the finances. You need to provide the power of attorney to banks and financial institutions and give them enough time to process them, because oftentimes they'll send it out to their legal department. I'm not convinced there's actually a lawyer there, but who knows? We don't really like it when we see people become joint owners on accounts. And that's because it allows that joint owner to be subject to creditors and divorce and things like that on your assets. And you think you're just adding them for convenience purposes, but you're really changing your estate plan too, because when you die, the assets go to the surviving. So don't do that for convenience purposes. A power of attorney will work just fine. We always suggest that you utilize professionals to help you, such as accountants. A lot of people don't realize that there are people out there called daily money managers that will sit down and write out your checks and keep track of your checkbook and balance your checkbook and keep all your tax documents ready to go to the tax professionals. They do a lot to help you remain independent in your home. And there are also care managers that we love that are trained to provide information about different living situations. They're familiar with all the different facilities and homes and things like that. They can tell you which ones are run well, which ones are not. They can overlook the medical care you're getting to make sure that things aren't contradicting each other. It's great because they can look at the medical and they can speak doctor language, so they can talk to these people. When I'm acting as a caregiver for my parent, it's too emotional for me. I can't really do a good job and advocate. And I think that the medical people understand this. So it's always a good idea to have a care manager that is solely representing that disabled person. And then this shouldn't have to be said, but Virginia and I see the worst in people. Ensure that you're acting in the best interest of the principal at all times.
Right. Okay, so what is supported decision making? This is a somewhat new development in the law that's intended for adults with some level of intellectual disability. So it's someone who has the capacity to understand decisions that they're making, and enter into contracts, because the foundation of supported decision making are these agreements, but may need a little extra help. So perhaps it's things with managing money, significant medical decisions, long-term planning, things like that. So with this, the individual who's entering into the supported decision-making arrangement can select one or more supporters to help guide their decisions. The threshold is the person needs to have the capacity to sign document like a power of attorney or advanced medical directive, and to select supporters to help make decisions for them. So it's a great development because it sort of allows a middle ground between guardianship, for example, versus complete autonomy and independence. It's in the middle. But it is really important to remember that the disabled person has to have a threshold level of capacity to sign the documents. So it could be family members, it could be professionals, it could be teachers, could be a variety of people and different people for different roles. But this is something that we're seeing more and more of, and it's a relatively new development in the law. And it's really a positive for people who may have some disability, but also want to maintain a degree of independence. So this is one of the questions that we get most often, and we've thrown around a lot of different terms in this presentation so far. So we want to answer the question, how do you know if you need to pursue guardianship and or conservatorship of your loved one, whether this is a young adult child or a parent or aunt or uncle or someone that you're caring for? How do you know if you need to take that step? So when I'm talking to someone and trying to help them work through this decision, the first question that we ask is, does the person have incapacity documents? Is there a power of attorney and or advanced medical directive and healthcare power of attorney? If the answer is yes, that's generally good news. Then we have to ask, are the documents effective? Are they doing what they do? So is the agent named doing his or her job? I've had certain cases where the agent under a power of attorney was doing a lot of the don'ts on the list that we looked at a few minutes ago. And in that instance, we did end up having to file for guardianship and conservatorship. Are the documents sufficient to meet the person's needs? So by that question, for example, if there's a real estate transaction that needs to take place, and Liz just talked about a power of attorney for real estate needs to be signed by 2 witnesses and notarized in order to be recorded. If we don't have that in the power of attorney, we may need to seek a guardianship in order to conduct that real estate transaction. Sometimes people with dementia or other disabilities, they may have a power of attorney, but it may not be sufficient because with a power of attorney, they retain the ability to manage their own finances. And sometimes, unfortunately, we see people falling victim to scams or just making really poor choices with their funds as a result of their disability. And so the power of attorney at that point is not sufficient because it's not safeguarding their resources.
We've been seeing a lot of those romance scams where
Yes.
people give away hundreds of thousands of dollars of their money, and there is a power of attorney, but it's obviously not working.
Right. That kind of goes to our next question. Is it easy for the adult to be manipulated or taken advantage of by others? Is it likely that they're going to revoke or terminate their documents? So sometimes some of these disabilities, we see a degree of paranoia or delusion, and people, because of those difficulties, decide that they're going to revoke or terminate their documents. So in that instance, the next question, if they don't have those documents or if they're not doing their job, does the person have capacity to create a power of attorney and advanced medical directive documents now? So sometimes we hear from clients, they say, oh, mom was just diagnosed with dementia, so we have to get guardianship of her. Well, not necessarily. Capacity runs along the spectrum. Sometimes it can even fluctuate day to day or hour to hour. So it may be that even though a person has a diagnosed disability, they still retain the capacity to enter into these documents. Are they willing to enter into them? Sometimes people really don't want to. If the answer to those questions is no, then you probably are in a situation where you need to pursue guardianship and or conservatorship of your loved one.
So now we're going to talk briefly about ABLE accounts. ABLE accounts came into play in 2015, and it stands for Achieving Better Life Expectancy. They are 529 savings accounts for people with disabilities, and it allows for tax advantages and tax-free distributions if it's used for certain expenses, and the assets in the ABLE account won't count as your resources if you're qualified for a means-based public benefit like Medicaid or SSI. So to be eligible for an ABLE account, you have to be determined to be disabled before the age of 26. The federal government just changed that law. So in 2026, the age goes up to 46. Don't know where they got that 46, but they must be disabled before the age of 46 then. And the disability determination, there are 2 options. Number 1, if you are already on SSI or Social Security disability benefits, then that's good enough. If you don't have those benefits, you can submit a physician certification. And some of the ABLE accounts have those forms on their web pages, so you can download it and take it to the doctor. So some of the particulars about ABLE accounts, you can only put in the annual gift tax exclusion amount on an annual basis. So this year it's $18,000. That's all you can put in for the full year. But some of the beneficiaries can contribute some of their compensation up to the poverty limits. So if they work part-time or they have some sort of assisted job situation, they can have that income go in to the ABLE account as well as the 18,000. There are limited rollovers permitted from the 529 college plans, again, 18,000 a year on an annual basis. So if you've got a lot of money in a college plan and you need to convert it to an ABLE account, it's going to be a process. For public benefit purposes, up to the first 100,000 is going to be exempt from counting for Social Security benefits for SSI. Once it gets 100,000, SSI is suspended. It's not terminated, it's just put on hold. And Medicaid still is in play up to the total amount that you can put into a 529 college fund. So in Virginia, I believe it's up to 550,000. So you might lose SSI, but you're not going to lose Medicaid. And that's important in states that are 209B states, or states that have different applications for SSI versus Medicaid. Some states they're linked and you have to have SSI in order to get Medicaid. A lot of the spending on the ABLE accounts is through a credit card, and in some cases you can limit what the amount is or how much can be spent. So it's a good way of sort of managing those monies a little bit better.
Yeah, the TrueLink card is great in a number of circumstances because you can also link it to a conventional bank account and allow a recipient to access funds on a limited basis. So you can set dollar amounts, you can allow certain types of expenditures, but not others. So it really is helpful for people with a variety of disabilities because, again, it can allow them to maintain some independence and some autonomy while allowing their caregiver to keep things somewhat under control.
You just did that for one of your clients that has a caregiver and has the TrueLink card. Mm-hmm. I don't remember what he uses it for, though.
Yes, I have it for a few of my clients. So I think they can go out to eat. Sometimes they can use it for transit, for groceries. I have a client who uses it at the grocery store. She uses it. She has a cat, so she uses it to buy pet food and things like that. So it's really helpful. Okay, so we wanted to talk about special needs trusts because this is an important tool for caregivers of loved ones with disabilities. And generally, these are special types of trusts that allows the beneficiary to maintain qualification for Medicaid and Social Security and other disability benefits. There are different types of trusts when we talk about special needs trusts: third party, first party, and pooled special needs trusts. Typically, these trusts are going to have to be approved by Social Security and Medicaid in order for the individual to maintain their benefits. And they're designed to supplement the beneficiary's needs. The idea is that SSI or Medicaid are providing for the basics, and these are for supplemental needs. And they really can work hand in hand with an ABLE account to provide for a lot of support for the individual with the disability. So when we think about a first party special needs trust, this is something I think that is confusing to a lot of our clients. They get confused about first party versus third party. But the big thing to remember with the first party special needs trust is that it is funded with property that ultimately belongs to the beneficiary. So it may be their own funds, if this is a disability that occurred later in life. It could be something like an inheritance or lawsuit damages, but it's their money. The beneficiary has to be 65 years or younger when the trust is established. And there are a variety of people who can establish the special needs trust. So we talked about limited conservatorships. Sometimes you need a limited conservatorship for the purpose of establishing or funding a special needs trust. During the person's lifetime, the funds are going to be used for their sole benefit. And one of the drawbacks of the special needs trust is that at the time of the beneficiary's death, the trust must first repay Medicaid, for medical assistance with any money that's left before that's dispersed to any secondary beneficiaries. The beneficiary cannot be a trustee of their own special needs trust. They can't have control over the money in that account. So a third party special needs trust, this is used for money that does not belong to the beneficiary. So could be coming from parents or grandparents who want to leave an inheritance to a loved one with a disability, something like that. But it's not the beneficiary's money. It can be its own standalone trust, and that is generally our preference when we draft. Having to do mostly with privacy reasons, things like this. If we're going to have to send the trust to Social Security, the Social Security doesn't need to know about what all the other grandkids are getting, for example. But it can be a sub-trust that is within another type of trust or a will. Court approval is not required for this type of trust. One of the big benefits is there's no Medicaid payback requirement. So after the beneficiary passes away, any funds that are left can go to other beneficiaries. So a pooled special needs trust is created by a nonprofit organization, and it's essentially an account within a larger fund. And there's some groups in Northern Virginia that we work with who run really well managed pooled special needs trusts. And one of the advantages of this is it keeps the administrative costs low because you're essentially pooling your resources and you're not having all the resources of administering your own trust. And it provides for a higher rate of return over time. It can also be really great if a family doesn't necessarily have someone who they think would be a good trustee to manage a special needs trust. And you want to have someone with expertise, someone who's trustworthy, then these pooled special needs trusts can be a really great tool because these are, as we said, well-managed trusts, experts in their fields, and you have a greater degree of confidence that the funds are going to be managed properly.
We often recommend them for people with severe mental illness because the family members don't want to serve as trustee. And these pooled trusts are used to dealing in situations like that. And it's not personal for them like it is for the family member. So it's often a good idea for that. And so we usually recommend those.
Right. So we'll talk a little about how to decide which type of trust is right for your child. So the first determination, as we said, is where's the money coming from? If it's the beneficiary's own money, then it will have to be a first party special needs trust. Are there going to be multiple people funding it? Then we're probably looking at a third party special needs trust, and we would want it to be a standalone trust. How much money is going into it? If it's a relatively small amount, then again, we may be looking more at a pooled special needs trust. And who will be serving as the trustees of this special needs trust in the future? If you as the caregiver are no longer available to do it, who can step in? And if there's no one that really fits that bill, then you may want to look at a pooled special needs trust. You may want to look at a professional trustee. There's different options depending on your specific situation. So how are these used in practicality? So as we said, they're not meant to pay for the person's basic needs. So things like food, mortgage, rent, certain utilities. Generally, the special needs trust will not pay for those because we don't want to reduce the benefits that the beneficiary would otherwise be receiving. However, they can be used for a wide variety of other expenses. So you see the extensive list we have here. There's a whole variety of things that can be paid for. So other utilities like internet or TV, eating out, entertainment, travel, other medical services not covered by Medicaid, pets, certainly things like care managers or other professionals. So they can really enrich a person's life and provide for a lot of additional opportunities and things for them to make life more enjoyable.
But we have a lot of people that tell us, my child is fine with the public benefits, but they don't realize that they're probably the special needs trust for this child. And it's sort of a bleak existence if that's all you have. You're living in a group home, you're getting Medicaid and SSI, and there's no extras.
Right.
So.
Right. Even something like transportation may not be provided by Medicaid, and if a person has medical issues that they can't use, conventional vehicle transportation, that's something that a special needs trust can pay for and can really be vital to that person.
We had a woman who had dementia and she was wheelchair bound. And so Medicaid was going to transport her to a doctor's office. And it took forever to, number one, get a wheelchair van. And number two, it took like 3 hours. She had to wait to get the return ride. And she had diabetes. And it just was so horrible because there's nothing we could do. If she had had a special needs trust, we could have paid for our own driver and our own van and had a lot better of an experience.
So preparing, knowing what to do, talks about a lot of different processes and options. So it's important to find someone who's well-versed in these areas. Reach out early. Don't wait until there's a crisis. We do, I think, more crisis planning than we would hope for. So we certainly can help in those situations. But generally, if you wait to plan, you don't have as many options. And we always joke about legal doom. Internet estate planning documents can create more problems than they solve. So be wary.
So what do you have to do to prepare? You have to think about decisions like who's going to care for your incapacitated adult disabled person when you die, or the agent who's going to manage your child or adult disabled person's finances if you become incapacitated, who's going to manage the assets upon your death, and what do you want to have happen when your adult disabled child passes away or when you pass away? And how are you going to divide it when you have adult disabled children and non-disabled children? How are you going to divide it up equally when the disabled child is not going to have the income potential as the non-special needs child? Where's this person going to live? How are they going to be managed? We have a client and mom lives in California, so there's a time lag even, and she tries her best to help her child, but we had an incident where friends were taking advantage of his card and using it for Ubers for their use and benefit, and it was just very frustrating. She really needed somebody with boots on the ground. We were able to get a care manager put in place to make sure that he's not being taken advantage of.
So we wanted to leave some time for questions. So thank you for listening attentively, and we're ready to answer any questions that Allegra will give us.
Perfect. Thank you so much, ladies. This is a terrific information, and we do have questions that came in. And folks, it is 12:50. If we have more questions, we can stay on an extra 5 minutes just to let everyone know. Our first question that came in is, so a general healthcare power of attorney would not allow us to access any psychological and other information. Is that correct?
That is correct.
Okay.
There are psychological advanced medical directives, and we call those the Ulysses Clause. It's a specific document that you can use that would allow you to access that information and to admit somebody to a mental health facility against their wishes. But you have to have a doctor on board, and the doctor has to sign that psychiatric advanced medical directive. We found, though, lots of times when they are in a mental health facility, if it's a state-run, the state-run facilities don't like to take those documents, and it's hard enough to get them to take a guardianship order, even if the guardianship order has special language about psychiatric issues. So those are tough cases.
Thank you. PDD designation and joint accounts avoid probate. Yes. POD requires death certificate and joint does not.
Okay, so payable on death designation, yes, that would allow you to avoid probate. And yes, generally the financial institution will require you to produce a death certificate. In my experience is those distributions generally happen pretty quickly after the person passes away once you get the death certificate. It varies, of course, in the financial institution, but generally we're talking about days or weeks, not months. A joint account, it depends on how the account is titled, but generally, yes, a joint account, the surviving owner continues to have access to those funds, and throughout once the person dies.
Thank you. My son with Down syndrome has pension funds from his employer. He is still working and not accessing those funds. In order to protect those funds from considerations by Medicaid waiver purposes, should I put them in an ABLE account or a first-party trust?
I don't think you're going to be able to put them into an ABLE account, but that is an option, or a first party. But while he is working, if he doesn't have access to those funds, they are going to continue to be exempt. And when he retires or turns, I think it's 59 and a half, and he can then access those funds, then it's going to be a problem. So you need to make sure that if you're going to continue as is, that there's some means of getting those funds into a first party special needs trust as soon as he's able to access those funds.
Right.
Thank you. Deposit box access. If 3 people have access and one dies, to the other 2, do the other 2 still have access?
This is one of those cases where there's the legal theoretical answer and then there's the real world answer. The legal theoretical answer is yes. I will caution people that I have had banks and other financial institutions do all kinds of things that are not necessarily supported by the law. I always caution my clients not to put things like their will or power of attorney in a safe deposit box for exactly this reason. You want your agent, executor, whomever to be able to access those documents if and when the time comes.
Even you have problems and you're a lawyer.
Yes, even I have problems. And sometimes it takes a court order or it takes qualifying as executor on an estate to get access to a safe deposit box.
Okay, thank you. If you have durable power of attorney and an advanced medical directive, is a guardianship necessary?
So that goes back to the questions that we went through. And so the answer is hopefully no, a guardianship will not be necessary because the point of those documents is to plan for incapacity. As long as those conditions that we talked about are met, as long as the documents are effective, the agent or agents who are named are doing their job, and the person is not endangering themselves in some way. For example, I've had cases where a person does have an advanced medical directive, but they have dementia and they are refusing needed help. So they're refusing to go to assisted living, or they're not allowing a caregiver to come in to care for them. And in those circumstances, we have had to seek guardianship because the documents are not effective.
My wife has Alzheimer's. She can take care of herself, but not her or our finances. I have made a bunch of things joint, but I treat her and hers and mine as mine. I think that's more of a comment for that one. Oh,
Yeah. And joint accounts are less problematic for spouses versus other types of relationships.
got it. If you have a very small family or circle of friends, how do you find someone to appoint as the trusted agent? Are there professional companies that can provide the service with bonds or other proof of trustworthiness?
Yes. So sometimes there's not a trusted friend or family member who is appropriate for this role. And in those instances, there are professionals who will do it. So there are trust companies, accountants, money managers, for example, who will serve as trustees or agent under a power of attorney. Some, not all care managers, for example, will serve as agent under an advanced medical directive. So there are various options for professionals. Certain attorneys will serve as professional fiduciaries. So there are options available.
Great. Are there laws that protect physicians making determinations of capacity? There is a form in Virginia that the physician must complete, but are there legal protections or liabilities particularly assigned? I'd hate to see an unscrupulous doctor working with heirs to prove grandma is incompetent to get access to funds.
That sounds like that movie that was on Netflix. Uh, do you want to answer that?
Sure. So there are certain laws, for example, the medical evaluation that's required for guardianship. Physicians are protected in filling out that form.
That's true.
So they still have to, they're protected from the HIPAA perspective, I should say, by releasing the information. They still have to be accurate.
That's right.
Okay. What does this mean? After death, the trust must repay Medicaid for all medical assistance benefits from any remaining funds. What would one owe?
So if let's use a disabled adult, you had a client with a Down syndrome adult child, and let's say that person is on a waiver. So Medicaid is kicking in to pay for housing, transportation, job coaching, all kinds of things like that. And Medicaid keeps a tally of everything that they spent. So when this person puts his assets in a first party special needs trust and dies, Medicaid is going to send that family a list of all of the expenses that they paid for over his lifetime, and they're going to expect to get reimbursed if there are funds still in that trust. If there are no funds in the trust, then they don't get anything. Or if the funds cover the costs and there's still some left, then that would go back to the family.
Okay, thank you. Is there a Medicaid payback requirement in a pooled trust?
A pooled trust has a first party and a third party, so it depends on which one you are funding. If it's a first party, yes, there is, but there are two options with the pooled trusts. One is they can elect to have the pooled trust company keep all of the money after the death of the person and continue to use it for other people with disabilities, or a Medicaid payback. With the third party, again, it can go back to family members. There's no Medicaid payback requirement.
Thank you. I want to bring my dad to Virginia from New York. I'd like to find an advocate to help me navigate through the state requirements to get him set up here. How can I go about finding one?
Advocate is a kind of a broad term, so I'm not sure exactly what help this person's looking for. I would say I can't recommend care managers enough. They can really be gateways to finding other resources. So I would start with a care manager and or an elder law attorney to help dad get settled and find out what services he may need.
Mm-hmm. And just to add in, you reach out to the area agency on aging. So,
Very good.
here you are. So on our screen, we have my direct number, but you're welcome to also call and we can get you connected to different resources. What kind of documents do you need after death?
Well, a will and or a revocable trust is what we look at after death. Generally, even if you have a revocable trust, there will be what's called a pour over will. So those are the documents that will guide the disposition of the assets. And then after the person's actually passed away, we're always looking for the death certificate that the funeral home will prepare.
Okay.
So those 2 or 3 things will get you started.
I have heard from friends that once their parents passed, even though they had the executor documentation, many places would not do anything until they had a death certificate, which in many cases took many weeks to obtain. Is there anything you can do to either expedite getting a death certificate or other way to be able to pay bills and close accounts?
Well, if you have a revocable trust during the person's lifetime, you don't have to qualify in the estate and wait for those things. That's something you have to do before the person passes away. I'm surprised that it took several weeks to get the death certificate. Usually those come pretty quickly from the funeral homes within a week to 10 days. Sometimes family members will pay certain bills, in the interim and then get repaid.
That's true. We had a case where the Social Security number was incorrect on the death certificate, and it took weeks to get it fixed. So maybe there was a mistake on it, or maybe they didn't get the required information to put on the death certificate from family members. That would slow it down as well.
Okay. Can you explain how the middle ground care situation works for someone who is psychologically impaired but is capable of entering into contracts?
So I think this person's asking about supported decision making. So Liz talked a little about the special advanced medical directive that can be very helpful for people who have mental health conditions. And what we see a lot of times with people who do suffer from those conditions is their capacity fluctuates depending on what's going on with their mental health. So generally, when they are in a period of relatively good mental health, we can work with them to get documents in place like a power of attorney and the psychological advanced medical directive, so that if they then experience a decline in their mental health and need additional assistance, their agents are at the ready and able to step in and help care for them.
Okay, great. Thank you. Does your agency also only help people in Fairfax, or do you also cover Arlington, et cetera?
Is that a question?
That may be a question for Allegra. Yeah. Well, our line helps people everywhere, but we'll let you speak for yourself.
Because I'm not sure which agency she meant. So if your office, you help Northern Virginia, correct? Or okay. And for my Fairfax area agency on aging, there is an area agency on aging in every county in Virginia. You're welcome to connect with us and we can help you connect to your area agency on aging, or you can Google area agency on aging and put your county in, and it should give you your phone number. How do you find a care manager for an adult child, not an elderly person? And I'm assuming an adult child is just someone 18 and up, so it would still utilize the same, am I right, Virginia and Elizabeth?
Yeah, there's various care managers that we work with, some of whom specialize more in different types of disabilities. And so we make referrals based on what the nature of the disability is. But we work with a couple who are wonderful with relatively young adults.
Okay. And then I have one last question. And then we'll wrap up our time. Transitioning my post-stroke mother with vascular dementia to in-home aides. I've been staying with her for 2 years and can no longer put my life on hold. My mother does not qualify for Medicaid or financial support. She has a modest annuity around 100K with about a 10K year free withdrawal. Beyond that amount, there's a withdrawal penalty. Annuity has a clause where penalty is waived if she goes into a nursing home. That is not acceptable. Is there a way around this clause so my mother can age in place at her apartment? Her doctors support her staying at home in familiar surroundings. Can we justify that the in-home arrangements are better and more suitable for her situation than being dumped into a nursing home?
That's certainly a tough situation. We would definitely recommend that this person reach out specifically. We can't give specific legal advice in this forum.
But oftentimes people say my mother's not eligible for Medicaid when they don't really understand what the criteria is to get them eligible. So Virginia's right. They should talk to an elder law attorney.
Right.
Okay, perfect. Perfect. Well, thank you both again so much for your time and your expertise. And thank you for staying over a little. It's 1:07, so thank you for staying later. I really want to thank our audience as well. Thank you for being here for more than the hour and joining us today. I know your time is precious as family caregivers. I did want to invite everyone to our next caregiver webinar, which is financial steps and resources for family caregivers. And that's going to be on Wednesday, June 26th from 12 to 1 p.m. Just another reminder to please fill out the survey and share with us what caregiving topics you're interested in for our future programs. Again, thank you so much, ladies, for your expertise, and I hope everyone has a terrific day and a good afternoon.
Thank you so much for having us.
Thank you. Take care, everyone.
Bye.
Bye-bye.